Alright, YouTube, let's finish this once and for all. The final part of Chapter 14 of The American Democracy by James E. Patterson. Here we go. Judicial restraint versus judicial activism. A long-standing debate over the judiciary's proper role has pitted the advocates of judicial restraint against the advocates of judicial activism. This debate centers on the degree to which judges should defer to precedent and elected officials. The doctrine of judicial restraint holds that judges should generally defer to precedent and to decisions made by legislatures. The restraint doctrine holds that in nearly every instance policy issues should be decided by elected lawmakers, not by appointed judges. The role of the judge is to apply the law rather than to determine it. Advocates of judicial restraint say that when judges substitute their views for those of elected representatives, they undermine the fundamental principle of self-government, the right of the majority, through its elective representatives, to determine how they will be governed. Underlying this argument is the idea that policy is the result of conflicts between contending interests, and that elected representatives, because they deal with these interests regularly, are in a better position than judges to determine how the conflict should be resolved. In contrast, the doctrine of judicial activism holds that judges should actively interpret the Constitution, states, and precedents in light of fundamental principles, and should intervene when elected representatives fail to act in accord with these principles. Although advocates of judicial activism acknowledge the importance of majority rule, they claim the court should not bow to precedent or decisions of elected officials when core principles such as liberty, equality, and self-government are threatened. In such instances, the judge should not hesitate to reverse precedent or to override executive or legislative action. Now, on the next page, we have a lengthy segment debating the issues. It's originalism versus... what is it called? What's the other one? Yes, the new constitutionalism. Open... oh god, I need to flip. Living constitutional theory. Originalism versus living constitutional theory. I'm not going to read it, but we have opposing opinions from Antonin Scalia and Stephen Breyer. So if you want to, buy the very expensive book. If not, let's keep going. Over its history, the Supreme Court has held strong proponents of each doctrine. Chief Justice John Marshall was an avowed activist who used the court to enlarge the judiciary's power and promote the nation's government. Judicial review, the most substantial form of judicial power, is not granted explicitly by the Constitution, but was claimed through Marshall's opinion in Marbury v. Madison. Associate Justice Oliver Wendell Holmes, Jr. was Marshall's philosophical opposite. One of the nation's most influential jurists, Holmes argued that the judiciary should defer to elected branches unless they blatantly overstep their authority. Holmes wrote the opinion in Schneck v. United States, 1919, that upheld Congress should pass no law abridging the freedom of speech. Holmes argued that the First Amendment does not prevent Congress from enacting laws prohibiting speech that results in substantive evils, such as rioting or in loss of life. Although judicial activism is sometimes associated with liberal justice, history indicates it has also been practiced by conservative justices. During the period between the Civil War and the Great Depression, the Supreme Court was dominated by conservatives and had an activist agenda, striking down most state and congressional legislation aimed at economic regulation. In the period after World War II, the court was again in activist mode, but this time in a different direction. Dominated by liberal justices, the court struck down numerous state statutes in the course of expanding fair trial rights and civil rights. In recent years, the conservative-dominated Supreme Court has also been an activist court. In the past 15 years or so, the Supreme Court has struck down more acts of Congress than were invalidated during the previous half-century. A case in point is the court's recent ruling on campaign spending, in deciding that corporations and unions could spend freely on election campaigns. The court overturned congressional action and also overturned precedent. The court had previously held that Congress could regulate corporate and union spending during elections. With another interruption from political thinking, judicial activism or judicial restraint. While philosophy, judicial restraint, or judicial restraint or judicial activism, comes closer to your own thinking about the proper role of the courts. Does your support for restraint or activism depend on whether a judicial decision conforms to your own preference on the issue in question? Yeah, very, very poignant. I'm not going to think about that. On to our final headline, and following that, the summary. What is judiciary's proper role? Like the debate between originalism and living constitutional theorists, the debate between advocates of judicial restraint and activism is a normative one? That's probably it. There is no conclusive way of setting the issue because the Constitution does not specify the method by which judges should arrive at their decisions. Nevertheless, the debates are important because they address the fundamental question of the roles of judges in governing systems based on the often conflicting concept is a majority rule in individual rights. The United States is a constitutional democracy that recognizes both the power of the majority to rule and the claim of the minority protection of its rights and interests. The judiciary was not established as the nation's final authority on all things relating to the use of political power. Yet the judiciary was established as a co-equal branch of government charged with responsibility for protecting individual rights and constraining political authority. The question of how far the court should go in asserting their authority is one that every student of government should ponder. Now, the summary. If you've made it this far, you should probably wake yourself up, slap yourself in the face, pour a glass of water on your head. I'm not going to. I love this chair. It's too nice to get wet. But otherwise I would, because I'm very sleepy. It's 11:50 Eastern Standard Time. Anyway, here we go. Pay attention. Pay very close attention. This is everything I've read. This is more than an hour's worth summed up in a few paragraphs. So pay very close attention. Look how weird my face looks up close. It looks very weird. Okay. At the lowest level of the federal judicial system are the district courts where most federal cases begin. Above them are the Federal Court of Appeals, which reviews cases appealed from the lower courts. The U.S. Supreme Court is the nation's highest court. Each state has its own court system, consisting of trial courts at the bottom and one or two appellate levels at the top. Cases originating in state courts ordinarily cannot be appealed to the federal courts unless a federal issue is involved, and then the federal courts can choose to rule only on the federal aspects of the case. Federal judges on all levels are nominated by the president, and if confirmed by the Senate, they are appointed by the president to the office. Once on the federal bench, they serve until they die, retire, or are removed by impeachment and conviction. The Supreme Court is unquestionably the most important court in the country. The legal principles it establishes are binding on the lower courts, and its capacity to define the law is enhanced by the control it exercises over the cases it hears. However, it is inaccurate to assume that lower courts are inconsequential, the upper court myth. Lower courts have considerable discretion, and the great majority of their decisions are not reviewed by a higher court. It is also inaccurate to assume that federal courts are far more significant than state courts. The federal court myth. The courts have less discretionary authority than elected institutions do. The judiciary's positions are constrained by the facts of a case and by the laws defined through Congress, the Constitution, legal precedent statuses. I added Congress, that doesn't exist. And government regulations derived from statuses. Yet existing legal guidelines are seldom so precise that judges have no choice in their decision. As a result, political influences have a strong impact on the judiciary. It responds to national conditions, public opinion, interest groups, and elected officials, particularly the president and members of Congress. Another political influence on the judiciary is personal beliefs of the judges, who have the individual preference that affects how they decide issues that come before the courts. Not surprisingly, partisan politics play a significant role in judicial appointments. In recent decades, as the Supreme Court has crossed into areas traditionally left to lawmaking majorities, the issues of judicial power have become more pressing, which has prompted claims and counterclaims about the judiciary's proper role. Advocates of originalism theory argue that judges should apply the law in terms of the words of the law as they were understood at the time of enactment. Advocates of the living constitution theory hold that law should be interpreted in light of changing circumstances. Judicial restraint and activism are two additional theories of the judiciary's proper role. Advocates of judicial restraint claim that justices' personal values are inadequate justification for exceeding the proper judicial role. They argue that the Constitution entrusts broad issues of the public good to elective institutions, and that the court should ordinarily defer to the judgment of elected officials Judicial activists counter that the courts were established as an independent branch and should not hesitate to promote general principles when necessary, even if the action brings them into conflict with elected officials. Well, what a wonderful book. What a wonderful book. I've been reading for like an hour and 10 minutes. I'm about to pass out. Farewell, YouTube. I hope you've learned something, at least had a few laughs along the way. Have a good night.